We know it's early. But what better way to start your day than by getting free legal advice? This is Vastola on the Law with your host, Attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, Attorney Jeff Vastola.
Well, good morning, everybody. This is Jeff Vastola, and I'm sorry it's not 7:30. It's almost 7:45. So I'm told that I'm live. Hopefully you can hear me. I am? Okay, great. Thank you very much, Evelyn, for stepping in this morning. Obviously some technical difficulties, but we're here. We're live now at about 7:41 or so. It's February 15th. 2020, just in case you're wondering if this is in fact live or a replay. And I've got about half of a show now to discuss some answers to questions that were presented to me during the week. And I'll be doing that. And also I'll be starting a trial next week, and I wanted to talk about the McDonald's case, because every time I go to pick a jury, that topic always comes up. People are still mad when they think they know about that case and how much poor Stella Lieback got paid because she poured coffee on herself. Well, anyway, I'm Jeff Vastola. I'm an attorney, and I'm here live to give you free legal advice. If you'd like to call into the show, you can do that. 877-850-8585. And if you'd like to talk to me about a case of your own, not on the air, in private, you can reach me on my cell phone by dialing 833-VASTOLA. That's 833-827-8652. That number is forwarded to my cell phone 24/7. You can reach me anytime that you want. Let's talk about automobile coverages, and specifically this is a question presented to me by a listener, Mike. He has, what I've explained to him already, a very strong automobile policy. He is wanting to renew the policy. He wanted me to take a look at it to see if I had any recommendations for him. And I would also encourage all of you to do the exact same thing, because Mike has, in a lot of respects, a great policy. But even though he's got a great policy, there are a couple of areas that can be improved upon, and I just wanted to touch on those things. Importantly, Mike has opted to carry bodily injury coverage, and he's also opted to carry the most important coverage, in my opinion, the uninsured motorist coverage. And what he's done is something very smart. He's opted for bodily injury liability of $250, $500, and he's got several vehicles on this policy, and so he opted for stacked uninsured motorist coverage, and therefore you can multiply that line item of coverage for an individual by the number of vehicles that are on it. So a $100,000 UM policy with a 4-vehicle policy means that's actually $400,000 of UM coverage. Now, Mike, something to consider. You have to have bodily injury coverage in order to carry the UM, but what you're doing is you're kind of shortchanging yourself, because you're paying for $250,000 of BI coverage. You could, in fact, get $250,000 of UM, the uninsured motorist coverage, and then stack that. And then if you stacked $250 instead of just $100 with the 4 vehicles on the policy, and I understand you told me one vehicle is going to disappear pretty soon, but if you stacked a $250 policy with 4 vehicles, you've got $1 million in coverage, and you're really only paying for the $250 UM stacked. Now, stacked is a little bit more expensive than the non-stacked, but it has its benefits, and it's really not that much more expensive. So certainly, absolutely, positively, Mike, look into increasing that rate, the UM rate, from $100,000 in benefit to $250. You should also consider, and I can't tell, because oftentimes umbrella policies are not included on an underlying auto policy, whether you have an umbrella policy. But if you do not, for everyone to consider, if you have a certain amount of underlying insurance coverage, you can get an umbrella policy that will cover everything, and you can get a $1 million umbrella policy for $400 a year. That's not even a 6-month premium. That's an annual premium. And then, of course, you can go up from there. You can get $2 million, you get $5 million, you get $10 million, whatever you want to pay for. A couple of more things here on Mike's policy before I move on to something else, and that is that I see that there's no rental reimbursement, and there's no roadside assistance, and there's no what we call gap coverage. On this policy, it's referred to as loan/lease payoff. Now, let me talk about each one of those independently. Rental reimbursement, it's pretty self-explanatory, but you don't understand how important it is until you need it and you don't have it. If you're involved in an accident and you say you've got one vehicle in the household and that vehicle is rendered inoperable because of an accident, the other driver doesn't necessarily always have insurance to fix your car. And if you don't have the insurance, or if it's going to take a while to get your car repaired, and if you don't have rental, well, then you're out of a car, or you're going to pay for a pocket. It's a lot easier to let your insurance company pay for the rental by tacking on rental reimbursement. Rental reimbursement on a 6-month policy is like, I don't know, $12, $20. It's not that much. So you reconsider if you've decided not to get rental, because it really is important. I see time and time again in my office where people they get mad, and sometimes they get mad at me, saying, well, how come the other driver's not giving me a rental? Well, the law doesn't require it. You're given the option of getting rental on your policy, so think it through if you don't have it. If you've got multiple vehicles in the household, if you can do without a car, if it's been totaled, or if it's being repaired, then obviously you may not need it, and that may be the situation here with 4 vehicles on a policy, but something to consider. Roadside assistance, this is, again, if you don't need it, then don't buy it. A lot of new vehicles now are coming with a certain term of roadside assistance. They'll say, hey, look, you get 1 year of roadside assistance, and people are like, great, I don't need roadside. Well, in year 2, you kind of forget that you don't have roadside assistance anymore with your new vehicle, and you've neglected to put it on your insurance policy. Well, something happens on the side of the road out in Podunk, Florida, it's going to be very expensive for somebody to come get you. So roadside assistance, again, is a very inexpensive coverage. If you don't have it, reconsider putting it on there, because it's one of those things. You could go a lifetime and not ever need it, in which case you may say, well, geez, I threw money away. But, that's the nature of insurance. But when you need it and you have it, you're going to be thankful that you've got it. When you need it and you don't have it, you're really going to regret that decision. Lastly, loan/lease payoff. If you have a vehicle with a loan on it, please make certain that you have gap insurance. This is the insurance that, let me just give you a very simple example. Let's say you've purchased a vehicle and your loan value, now your loan value equals the value of the car plus all of the interest and stuff that's tacked onto that, so that you can finance the vehicle and take it out of the showroom. Okay, so let's say your loan price is $50,000. If you get into an accident, and that car is totaled, the insurance company may say, well, you know what? The actual value of the vehicle is only $40,000. The insurance for the other driver is not obligated to pay you for all the interest and other stuff that you tacked into a financing agreement. The insurance company, if you're lucky, if the other driver has enough property damage coverage to actually pay you $40,000, mind you, the state required minimum is only $10,000. All right. If the other driver has the $40,000 to give you, that's a problem because you owe $50,000. Where's the other $10,000 going to come from? It's a really big problem if the other driver only has $10,000. That's an extra $40,000. Where are you going to come up with $40,000 to pay off a car because somebody else caused an accident? That's what gap coverage is for. It will cover the difference. So please make sure that you have gap coverage on your policy. If you have any questions about those, call me anytime. You can email me like Mike did. You can call me. I'm always happy to discuss insurance coverages because I know how important it is. It's not something that I just philosophically feel it's important. What happens is in my line of work, Monday through Friday, people come into my office and I see how decisions that they've made in the past affect them now. And what's really difficult to understand and to accept is that these decisions that you've made 6 months or a year ago, sometimes 5 years ago, because people just renew their policy constantly, these are decisions that you can't go back and fix retroactively. If you're involved in an accident, what you had in place at the time is what you're stuck with. So make sure that if you're involved in an accident, you're stuck with a good policy. So Mike, in summary, your policy is a very strong policy, but there's room for improvement. So as I recommended, reach out to my agent and see what he can do for you, because I'm confident that he'll be able to save you a little bit of money. I need to switch gears, and I need to respond to a question from a person that reached out to me during the week about a family law matter. Now, I've made it very clear to her that I'm not a family law lawyer, but she's reaching out to me because she heard about the show and she wanted to know what I could do. An ex-husband has filed a motion for relief from judgment. This was a final judgment that was entered based upon the parties' mediated agreement where they came to terms on all of the relevant issues. Well, apparently there was some efforts at reconciliation that didn't work out, and now the ex is filing this motion for modification of the agreement and citing several different reasons why the final judgment, which is dated back in apparently 2010, needs to be set aside with apparently a new modification or a new agreement, or perhaps even just a new final judgment if it's decided by the judge, with quite a bit of modification to it. Well, interestingly enough, as I sat down to sift through this, the documents that were emailed to me, it occurred to me that just the week prior on my show, I talked about a very recent case. I do a case law update. I try to every week. And last week I had talked about the case of Hutchinson versus Hutchinson out of the 1st District. And of course, you know, you can shepherdize these cases, and I did that. And I found a case out of the 4th DCA that was somewhat similar in holding. But in order to get a modification, it says to be entitled to modification of time sharing, the moving party must show that circumstances have substantially and materially changed since the original custody determination. The change was not reasonably contemplated by the parties, and the child's best interest justified changing custody. And of course, there's also a request in this particular matter to modify the amount of the child support. Now, the bases are a little bit different than what's set forth in the Hutchinson case, but the Hutchinson case states the parties' varied time-sharing schedule, Ms. Hutchinson's local moves, and the child's change of middle schools does not establish a substantial change in circumstances sufficient to support a modification of the previous final judgment. In order to seek modification, you have to have some substantial change in circumstances, or as I can see from this particular motion that was filed, suggestions of alternative theories. Similarly, there's going to be a hearing. The judge will take evidence, and based upon the presentation of evidence from both sides, a determination will be made as to whether the motion filed by the ex-husband is valid or not. But essentially, that's what has to be proven, is a substantial change in circumstances, unless the ex is able to convince the court that the entire thing should be thrown out for the reasons stated. Now, again, I'm not a family law lawyer. I've never handled family law in my life, but that's essentially the foundation from which the case will be built. If there's any follow-up to that, please let me know. I realize that's not an answer to the question of is my ex going to be successful in what he's filed, but you know, without sounding too facetious, I don't have a crystal ball. I have no idea what's going to happen when the judge takes in all of the evidence, applies it to the law, and then makes a final ruling on what's going to happen. But essentially, that's what that's what the ex will have to show, among other things. So I'm always open to follow-up. If anybody has any questions, commentary, please feel free to call in. The number to the show is 877-850-8585. Again, I apologize for the first 10 to 15 minutes of the show. I know there was dead air, and I know then they started playing the Good Greeks moving program, and I hope that didn't throw anybody off. But I am here. I am attorney Jeff Vastola. I'm here for about another 5 minutes, and I want to spend these last 5 minutes talking about hot coffee. You may say to yourself, wow, that's a change. How does hot coffee apply to the law? Well, of course, anytime trial lawyers in the state of Florida, I shouldn't say anytime, I would say most times, trial lawyers begin to pick a jury in an injury case, the case of Stella Liebeck typically comes up. Now, show of hands, who knows Stella Liebeck? Anybody heard of her? She's the unfortunate elderly woman. Back in 1992, she was 79 years old, who drove through a McDonald's drive-thru, ordered coffee, and the coffee ended up spilling in her lap, into her crotch area, the privates, and she had substantial third-degree burns and required surgery and stuff like that. Well, what happens is most people simply hear that McDonald's had to pay somebody that spilled coffee on herself $1 million, and it triggers outrage. People say, "Oh, where's the accountability?" And I can understand that if the case were that simple. So what I typically have to do, to the extent the judge will allow, is go into some of the more minute details of the Stella Liebeck versus McDonald's case so that people really understand that it wasn't as simple as that. It wasn't just that Stella spilled coffee on her lap and, poor McDonald's had to pay her $1 million. That's not what happened. Some of the evidence the jury actually heard consists of this. McDonald's operations manual required its franchisees to hold its coffee at 180 to 190 degrees at all times. There was expert testimony in the trial about that mandate. Specifically, any liquid at that temperature, if spilled, causes third-degree burns in 3 to 7 seconds. McDonald's admitted that it had known about the risk of serious burns from its scalding hot coffee for more than 10 years, and that the risk had been brought to its attention many times with over 700 prior claims from people being burned by its hot coffee. Now, you may say to yourself, well, yeah, come on, coffee's hot. Coffee's hot, but you don't have to keep it at that temperature. Thank you, Evelyn. The temperature at which McDonald's was keeping their coffee was a temperature at which they could keep their coffee for several hours a day instead of having to pour it out every hour and make a new pot. And that was really the difference, is that the testimony that was presented to that jury is that McDonald's could have kept its coffee at a lower temperature that would not have caused those serious injuries. And let me see what else. McDonald's admitted that the consumers were unaware of the extent of risk of serious burns, even though it knew. McDonald's knew that it could not pour its coffee into styrofoam cups because it would immediately burn the mouth and the throat. One of the jurors was actually quoted after the case to say, in a Wall Street Journal interview, that she thought the company wasn't taking the injuries seriously, meaning Stella's injury and the 700 prior cases. She says, to the corporate restaurant giant, those 700 injury cases caused by hot coffee seemed relatively rare compared to the millions of cups of coffee it served. And that was the position McDonald's took. It's like, oh, collateral damage, no big deal. Look at all the number of cups of coffee we pour a day. But that juror noted that there was a person behind every number. That number is not just a statistic. That's actually a human being that you're hurting every single time. And there were more than 700 injury cases before Stella's case. And she just didn't think that, she and the rest of her juror members did not think that McDonald's was placing any significance to the actual injuries themselves and the people. So essentially what they did, the compensatory damages were like $85,000 because she had surgeries. The punitive damages was an amount equal to 2 days' sales of coffee for McDonald's around the country. That's how they came up with the punitive amount to be assessed against the McDonald's. So the next time you hear about the McDonald's case, you can say, hey, wait a minute. I know there's more to it than then this old lady poured coffee on her crotch and got $1 million. I'll be talking about it next week, I'm pretty sure. Thank you so much for tuning in. This has been Vastola on the Law. If you have any questions and you want to talk to me, call me at 833